Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to talk to you about Social Security disability appeals and how to make arguments that are going to win your case. And I want to talk about really, I think, the top 7 tips I can come up with. And these are things I think that a lot of people don't do. So if you do them, your chances of winning are going to go up. And of course, they don't apply in every single case, but I want you to understand what I think are the top 7 ways that you can win your case early when you file your disability appeal. Number 1 is look at the Social Security listings, because the listings are the fastest and simplest way to win your case. And the reason for that is the listings reflect medical considerations only. They don't really talk so much about vocational issues. So if you meet the listing, if you meet the medical requirements, the adjudicator, the claims adjuster, who's making the decision at the initial and reconsideration stage, only has to look at medical issues. So if you can identify a specific listing that you meet and you point that out in your appeal, it's going to improve your chances because the adjudicator will have something specifically to focus on. They don't have to think. Secondly, is you want to focus on reliability factors, and that is, when you fill out the forms and you talk about answer the various questions, you're answering every question in terms of how your medical condition makes you less reliable at work, and specifically the likelihood that you would be missing excessive days from work, that you would have to take unscheduled breaks. These are all reliability factors, and so when you combine that with the listing argument that you are not reliable, basically you're telling the claims adjuster, the adjudicator, that you would not be a reliable employee, which fits in with the definition of disability having to do with not being able to reliably perform substantial gainful activity 8 hours a day, 5 days a week, ongoing. Number 3, point to specific diagnostic test results that support your argument. So if your condition is one that can be identified with an MRI or a CT scan, an ultrasound, some sort of diagnostic test, and you had that test on April 29th, when you fill in the forms, you can reference the MRI I had on April 29th shows 3 herniated discs. Again, the adjudicators are not judges, they're not attorneys, they're claims adjusters. So if you can make their life easier by pointing out to specific objective tests, it's going to make it easier for them to say, yes, this person has a severe impairment. I don't have to make a judgment call. I can simply look at objective test results and recommend approval based on that. So if you have objective tests, good thing to point out in your forms. Number 4, and nobody does this, and I think if you do it and you can do it successfully, you're going to win, point to the grid rules. If you've seen my other videos, you know there are 3 ways you can win a disability case: meet a listing, argue functional capacity, or argue the grid rules. And if you look at my website, gridrules.net, you can learn all about the grid rules. But basically the grid rules reflect the reality that people who are over age 50 with a limited education, limited work skills, and a physical impairment, only physical impairment, not mental, but a physical impairment, are going to find it much more difficult to find work. So if you are over age 50 and you otherwise meet the grid rule and you can point to a specific grid rule, again, you're making that adjudicator's life a little bit easier, and you stand a much better shot at winning if you in fact do meet the grid rule. Number 5, if you can get your doctor to fill out a functional capacity evaluation or write a narrative report that tracks the language of the listing or that focuses specifically on job reliability issues, you'll be ahead of the game. Again, your adjudicator needs to hear from your doctor that you would not be a reliable worker. And again, either you meet the listing or you've got significant functional capacity impairments, but that needs to be stated very explicitly. Don't make the adjudicator read between the lines. Give it to that adjudicator specifically and have your doctor help you by writing a narrative report or completing a functional capacity evaluation. Number 6, if you have multiple medical conditions, and a lot of people do, they may have some depression, they may have some arthritis, they may have fibromyalgia, they may have a lot of different things going on. Focus on one major condition, specifically the one condition. If you've got numerous ones, if you've got one and at most 2 where there's objective evidence, focus on that. You can mention the other things, but don't make it difficult for the adjudicator to pick something out. In other words, the adjudicator is looking at, if they see on your forms, you're saying, I've got 6 things going on. I've got PTSD, and I've got vascular problems, and I've got diabetes, and I've got arthritis, and I've got asthma. They're not going to know which one is the most important, and they're just going to deny. But if you've got one, especially one where there's an MRI or a CT scan, like a herniated disc, or you've got blood clots that are demonstrated by ultrasound, focus on that as the main thing. That makes life a lot easier for everybody. Again, include the other ones, but really focus on that one main condition as the main reason why you are not able to function at work capacity, and keep coming back to that in your forms, that you're talking about how this impacts your capacity to work. And number 7, and again, this is sort of runs throughout anything you fill out with Social Security, be specific. Never say, I can't lift very much, I can't walk very far. I can only lift 4 to 6 pounds. I can only walk 3 city blocks. I can only stand 15 minutes, whatever the case may be. The more specific you can be, the more that adjudicator can plug that into a formula and see that you would not be reliable. If you've got to take a break every 45 minutes for 30 minutes, that's not consistent with competitive work. But if you say, I need to take periodic breaks frequently, that doesn't say anything. So avoid frequently and all the time and often, and focus specifically on hours, weeks, days, pounds, minutes, something that can be measured. So if you keep all those things in mind when you're filling out your appeals forms, even your initial application, but certainly your reconsideration form, that increases your chances greatly at getting approved early. And of course, if you have any questions, you need legal advice about some of this stuff, please feel free to give me a call, reach out to me by email. Happy to try to help you any way I can. Again, I'm Jonathan Ginsberg. I'm a disability attorney, and I help people all the time trying to get approved early. And if we can get you approved early, that's certainly a positive. I'm happy to try to do that. If you found this video useful, please give it a thumbs up on YouTube and a like on Facebook. Subscribe to our channel. I've got a lot of videos here I think you'll find very useful, and our Facebook page has got a lot of interesting information as well about how you can get approved early and what Social Security is looking for. But that's really the bottom line. Give them what they're looking for. Make it easy for the decision maker to find you disabled by giving them specifics as to what they're looking for, and not making them search through the record to find information about you. Lay it out for them very clearly and simply, and make your case clear and bold, and don't hesitate to talk specifics. So anyway, this is Jonathan Ginsberg. If I can be of help to you again, please let me know. Thanks a lot.